to Crime in Court. My name is Heather, and this is another episode of my Wrongful Conviction Series, Innocence Lost, and we are going to be talking today about Marvin Grimm Jr., and he was exonerated after 45 years for a crime that he did not commit, and we're going to get into that a lot more here. So, I if you're not familiar with my channel, I do a weekly Innocence Lost episode. I usually feature someone from the Innocence Project, but occasionally I might switch it up with some other story that I find here or there. But for the most part, a lot of my content comes from the Innocence Project. This is the Innocence Project that's based in New York, and they publish articles. They have information on different cases, different people who have been exonerated. They have exonerated over 200 something cases now. I don't know the exact number, but it's definitely over 200. And an interesting thing about the case that we're going to be discussing today is that Mr. Grimm, the man who you see on the screen, he had served the most years in prison than any other client of the Innocence Project. So, uh, this article is brand new. It was written June 21st, 2024 by the Innocence Project staff. So, as you can see, there is Marvin Grimm Jr. with his sisters. Apparently, it says, "I am a proud brother of wonderful, sweet, and awesome sisters." So, yes, and it's a picture of him and his sisters. All right, so what is this case about? Richmond, Virginia. Oh, sorry, that's that's where this was written. The Virginia Court of Appeals exonerated Marvin Grimm Jr. 48 years after he was wrongly convicted of the M and SA of a young boy in Richmond. The court issued a writ of actual innocence, which is very rare that they actually claim someone is innocent. And this officially cleared Mr. Grimm of the crime based on new evidence and new DNA testing, and also advances in what we know now about coerced confessions, which happen, my friends. They happen a lot more than we would like to admit. And that's why learning about this is so important, and hearing these cases is so important to figure out how innocent people can be put in jail. What's that saying? Like, injustice on one is injustice for all. We should be furious that innocent people are being sent to prison on very little evidence or coerced or forced confessions. There's a lot more involved, and these cases are much more black and white. And that's why I like looking at the legal aspects and reading through court documents and things like that, so I can actually make up my mind for myself instead of just hearing, what the media or whomever it might be who is that's feeding the narrative is putting that out there. I want the information for myself. So, and then when you do look and you look further and deeper into these cases, you see that there is corruption, cover-ups, misconduct, unethical behavior on many people who are in positions of power. So that's why, again, that's why I do this. This is important stuff that we as a society need to keep our eyes on and make sure that it's not happening. And if it is, it's our job to correct it. We need to speak up and speak out about it. So, anyways, all right. So, the court, like I said, issued actual writ of innocence. So Mr. Grimm spent 45 years wrongly incarcerated, more time in prison than any client exonerated by the Innocence Project for a crime he did not commit. He was released in 2020 on parole and required to register as an SO despite his innocence. So think about that. That's something that tarnishes your character for the rest of your life. If you didn't do that crime, and you have to register as an SO, that itself is heartbreaking. When you also factor into the whole situation that he lost 45 years of his life. That's more years than I've been alive at this point, thankfully. I'm young. Not that young, but um that's 45 years of your life just gone. How can you even have hope anymore after that? I mean, it just it takes a really strong person, and it says a lot about Mr. Grimm's character that he's just looking all chill and smiling with his sisters here. And he um, just seems content to be out, to be able to have a life again, because his life was taken from him. He's the innocence that was lost here, as well as the victim. I'm not saying the victim isn't, but I'm saying Mr. Grimm is one of our innocents lost. So Mr. Grimm, 1976 conviction hinged on a false conviction which was coerced under threat of the DP and forensic evidence linked to Mary Jane Burton, a senior forensic analyst at Virginia's State Crime Lab whose work had been mired in controversy for the last 2 decades. So, a false coercion or a coerced confession with a threat of losing your life, and also a forensics tech who was very controversial at the time, and she had a lot of cases that had been turned over in the last 2 decades. Think about that. Think about it if it was you in Mr. Grimm's position. You were forced to confess because if you didn't, they were going to threaten you, or they were going to give you the DP, which um, that's really only the prosecutor who can make that call, but criminals don't always know that. And then the forensic evidence tech who had been, well, let's just read on. Ms. Burton, the evidence tech, routinely saved forensic evidence in her notebook rather than returning it to the relevant law enforcement agency as required by protocol. Following the exoneration of Innocence Project client and board member Marvin Anderson, so a different Marvin, whose wrongful conviction for R was overturned after DNA testing of swabs in Ms. Burton's notebook, a state audit of other Virginia serology cases led to the exoneration of approximately another dozen people. So, roughly 12 people, plus this Marvin Anderson guy. And now we're looking at Marvin Grimm. So, years of post conviction litigation and appeals by the Innocence Project, as well as lobbying efforts by the Innocence Project's policy department to change Virginia laws allowing access to post conviction DNA testing, revealed new evidence as Mr. Grimm's evidence. Sorry. First, at the time of Mr. Grimm's conviction, Virginia used hair microscopy, a method of hair comparison whose validity has been questioned since the 2009 National Academies of Sciences, Engineering, and Medicine report Strengthening Forensic Science in the United States, a Path Forward. So we know now that hair comparisons it's junk science. You can't say definitively by looking under a microscope that this hair belongs to this person. You really cannot. All right, so Ms. Burton had claimed that 8 hairs of the young boy who had been whose life had been taken were found in Mr. Grimm's car and on his coat. New DNA analysis of the hairs showed that none of the hairs collected matched the boy's DNA, and that 7 of the hairs had different DNA profiles, indicating that they had been shed by 7 different people. So these hairs that are supposedly from this particular crime, Mr. Grimm's case, they submitted these hairs for testing, DNA testing now, and it's 7 different individuals for the 7 different hairs that they found. So, and um, Oh, I was gonna see if they had anything on the notebook. If she's saving samples in her notebook, which I don't know how you would do that, but if you did, I mean, there would be total contamination all around. So I don't know how she was doing it, but obviously there was contamination happening in the lab for at least 2 decades because at least 12, 13 people were let out because of her findings. And if you're putting people away, if your job has anything to do with putting people away for life or taking their civil liberties away, you should really, really be careful at what you're doing and really take a hard look at yourself to make sure that you're not following any kind of confirmation bias in your analysis or your investigation, whatever it might be. If you have some some kind of responsibility to put somebody away from their for their crimes, and I say crimes because you're not guilty until you're found guilty, but if there's someone that, you know, has a job out there that is anything in the realm of true crime and putting people away, just be really careful. That's all I'm saying, because we are coming to find that most of the things that are happening is a lot of it is personal error, like human error, like law enforcement forcing a confession or the prosecutor forcing a confession versus getting the DP. So, anyways, power, control. If you're in those positions of power, you need to be careful. You control someone's civil liberties. All right, so second, the deputy chief medical examiner, Dr. Marcella Fierro, erroneously claimed that a glob of white substance observed in the rear of the child's throat was a serological sample. And Dr. Fierro swabbed the white substance and claimed that she saw sperm upon microscopic inspection, post conviction microscopic examination by three separate laboratories of the liquid recovered from the same swabs revealed that there was no sperm present. Additionally, new DNA testing proved that the swabbed material only contained the child's DNA. So, not even a mixture. So, it was something from the child's own body that was produced there. Okay, so currently, like maybe he gurgled up some bile or something in the, process of dying or whatever it might have been, could have been something like that. And they took it as something incorrectly. They investigated it and or interpreted it. That's the word I was looking for, as something different. So currently, the Virginia Department of Forensic Sciences experts believes that the white substance was most likely phlegm, bile, something along those lines. All right, so third, the state's toxicology report revealed quantities of alcohol and muscle relaxants in the child's blood and several organs. However, the state crime lab and prosecutors ignored the impact of the toxicology results at the time. Post conviction analysis of the substance absorption proved Mr. Grimm could not have drugged the boy between the time the child was last seen and sightings of Mr. Grimm after the child was reported missing. Wow. So, from basically what that's saying is from toxicology reports, they were able to find that the boy was drugged long before Mr. Grimm could have even had him because he wasn't even reported missing at that time. So, new evidence of Mr. Grimm's evidence also includes developments in false confession research, which have shown that false confessions are more common when the trial penalty, where a more draconian sentence is threatened if a person accused of a crime exercises their constitutional right to trial, is at play. So basically, what I said. So, and this is kind of like what happened in the Karen Reed case, only she didn't plead out. So I'm going to use that as an example. So in the Karen Reed trial, if you're not watching it, it's fantastic trial, amazing to just watch this unfold before our very eyes. It's like nothing we've ever seen in our lifetimes. So, in the Karen Reed trial, she was first charged with unintentional or unintentional manslaughter. Okay, so just manslaughter, and potentially an OUI, which is their version of a DUI, which is operating um, under the influence. So and leaving the scene of a crime, basically. So those were the charges against Karen Reed. Well, later they upped her charges after grand jury testimony or grand jury hearing, and they upped her charges to second degree homicide, which there's no proof that she was even drunk to begin with because we've seen footage of her at the bar, but she only took like 2 drinks or 3 drinks or something like that. It wasn't a lot, and we don't know all of them, and we don't know what was in her glass. Everybody has testified that they didn't know what she was drinking. So she could have had seltzer with a little vodka and she was pouring in her own amount of vodka, so she wasn't drinking a lot. She has digestive issues, blah blah blah. I don't want to get into all of it, but they haven't even proven that she was drinking. But so they wanted to up the charges to second degree homicide. And I think with that, they wanted her to just plead out and say, okay, I'll take the plea for the lesser charges, the manslaughter and the OUI, and then take a lesser sentence instead of going for the double homicide charges and going to trial and all that, which is what she absolutely has a right to do. And she has done. And now she's exposing all the corruption that is happening there. But that's for another stream. So it's a good example of you get charged with one thing and it's manslaughter, unintentional manslaughter, and then suddenly it's second degree homicide, and they want you to plead to the lesser charge so they don't have to take you to trial. They don't want to pay for the trial. They want to put you away. That's what they want to do. So 26% of known exonerees accepted a guilty plea despite their innocence. In Mr. Grimm's case, he was coerced into a guilty plea after falsely being told that he could be sentenced to the DP if he went to trial and lost. However, his lawyer had failed to communicate that he, in fact, would have been ineligible for the DP and had he taken it to trial. So he didn't even converse with his lawyer, or his lawyer didn't even tell him that that was never going to be an option. So don't take the deal. But for whatever reason, he did not get that information. So Mr. Grimm was his own best advocate seeking DNA testing in the 1980s before the power of DNA to expose wrongful convictions was fully recognized. We are grateful that the Attorney General reviewed the evidence and agreed that Mr. Grimm is innocent. Finally, Mr. Grimm has some measure of justice, said Susan Friedman, Mr. Grimm's former Innocence Project attorney. And there he is in 1973, graduation of, I don't know, I think that's the Marines, U.S. Marines. I can't tell by his hat, but I think that's the Marines. All right, so a false confession. In November 1975, a mother reported her young son, referred to in court documents as CH, missing. After a search, his body was found on the southern banks of the James River. Mr. Grimm, who lived in the apartment across from the boy and his family, became a possible suspect due to previous arguments and encounters with the boy's family. Okay, that's just wrong. If the neighbors were just like, yeah, we don't like him, so we're going to say he did it, or just automatically assume he did it because of confirmation bias. So, after completing a 9-hour shift at work, Mr. Grimm was brought in for questioning on December 16th, 1975 at 2:20 a.m. After approximately 9 hours, so he just worked 9 hours, and then he got interrogated for another 9 hours and 18 hours after he started his workday. Mr. Grimm gave a recorded statement to police adopting the theory that had been posited, he adopted the theory that had been posited by the by the deputy medical examiner. Sorry, words are hard sometimes. All right, so Mr. Grimm falsely confessed that he had abducted, you can see that word for yourself, and MCH. So SA'd CH. The first 8+ hours of his interrogation were intentionally not recorded. So over 8 hours of his interrogation, not recorded. So the last hour, after they've already been into his head and tried to force him into thinking that he might have something to do with it, using all sorts of tactics that make you think that you need to confess in order to get out of whatever situation you're in, that's what detectives use. So he's going to give some kind of confession just to get the questioning over with. Mr. Grimm's recorded confession also did not make any reference to drugs and alcohol found in CH's system during the autopsy. So he had no knowledge of that, or proving or showing that he had no knowledge of that. And if it wasn't fed to him by the police, then it wouldn't have been in his report, in what he was saying in his confession, whatever. All right, so Mr. Grimm's false confession. Let me try that again. Mr. Grimm's false confession was demonstrably unreliable, said Peter Neufeld, who co-founded the Innocence Project and served as one of Mr. Grimm's attorneys. The court found that the version of the crime fed to him by the detectives was incompatible with the contradicted it was incompatible and contradicted by all the scientific evidence. So on March 10th, 1976, in exchange for the state agreeing not to seek the DP, Mr. Grimm pleaded guilty to homicide, SA, and abduction with the intent to defile. The court, that must have been like a intent to defile. Is that an old legal term, or is that still being used in Virginia today? I wonder. The circuit court accepted the guilty plea subject to a hearing on the evidence. Here's the state's flawed case. On March 15th, 1976, to satisfy the need for corroboration of the plea, the circuit court heard a summary of the state's evidence against Mr. Grimm. In addition to testimony from police and Mr. Grimm's confession, the state presented forensic evidence analyzed by Ms. Burton, the one whose convictions who she worked on had been overturned, at least a dozen. So this evidence included Ms. Burton's lab report with results from microscopic testing of the 8 hairs found in Mr. Grimm's car floorboards and on the child's sock in the car, as well as on a pea coat found in his apartment. He was military, so he probably did have a pea coat. Ms. Burton visually inspected slides made from swabs of the pharynx, I'm not even going to say all these words, esophagus, nasal passage, and oral cavity, and a towel recovered from Mr. Grimm's car that had a stain indicating the presence of what she believed to be a serological stain. Dr. Fierro, who performed the autopsy, also testified erroneously that there was spermatozoa on the thick white gelatinate material in CH's mouth. After hearing this forensic evidence and the testimony from officers who obtained Mr. Grimm's confession, the circuit court accepted Mr. Grimm's guilty pleas on all 3 counts and sentenced him to life in prison on the M and abduction charges, plus 10 years on the SA charges. So new evidence of Mr. Grimm's innocence. After years of post-conviction litigation, in April 2023, the attorneys from the Innocence Project and Arnold and Porter submitted a petition for writ of actual innocence before the Virginia Court of Appeals, seeking to vacate Mr. Grimm's conviction, his homicide conviction, based on newly discovered DNA and non-biological evidence. The Virginia office of the Attorney General joined the petition. What? The office of the Attorney General in Virginia joined the petition. That's cool. On June 18th, 2024, the Virginia Court of Appeals granted the petition based on the newly discovered evidence, including DNA evidence in uh, in 2011, the Virginia Department of Forensic Science performed DNA analysis of the 8 hairs found in Mr. Grimm's car, a sock. We read all this. Okay. Through this testing, CH was excluded as the source on 6 of the 8 hairs. Testing on one of the 2 remaining hairs was inconclusive, and the other lacked sufficient mitochondrial DNA to make a meaningful comparison. So when you actually go and dig deeper into the DNA results, you can see that nothing matched CH. But if you hear from someone on the stand saying, oh, well, the testing from these 2 remaining hairs that were inconclusive, those could have been, like they could spin it somehow when they're on the stand, like, well, those were blah, blah. So they could still say that it was connected to CH, and a jury not understanding the complexities of DNA and how you have to look at all the different areas of it, um, they're probably going to convict if they hear it from the DNA analysis themselves. I mean, it makes them think, gives them some sort of um, weight to their testimony because they're supposed to be the experts in this. But if they're just going around and putting DNA in their notebooks and contaminating every source that they get, it's going to be a problem. So the testing, I read that. Okay, so thanks to changes in Virginia law, the 2 remaining hairs were sent to a private sorry, accredited is not a word, accredited laboratory that was able to analyze the 2 remaining hairs. CH was excluded as the source of both of the hairs, and they were determined to be from different sources. So again, 2 different sources. These 2 hairs that were supposed to both be from the victim actually are not, neither one are from the victim, and they are both from 2 separate individuals. So yeah, where'd they get that? Our supposed conviction DNA analysis also eliminated Mr. Grimm as a possible contributor of the genetic material detected in the swabs taken from the boy's throat. Further examinations by the Virginia Department of Forensic Science and two leading private labs of the white substance that had been collected on swabs found no spermatozoa, disproving the medical examiner's theory on the case. And again, they thought it was phlegm, maybe bile, something along those lines, something produced in the boy's body. So toxicology reports were also skewed, given false information. Dr. Jeffrey Brent, a board certified medical toxicology physician with a PhD in biochemistry, reviewed the toxicology reports developed during the autopsy of CH. In conducting this review, Dr. Brent considered the quantities of the substances present in CH's system, the amount of food identified in his stomach, and his physical size. When all these factors are taken together, Dr. Brent concluded it was more probable than not that CH ingested the alcohol and all the drugs found in his system at least 90 to 150 minutes prior to losing his life. This timeline of events would have made it impossible for Mr. Grimm to have committed the crime, since it was undisputed that he was alone in his apartment within 75 minutes after the mother of the child claimed that she had last seen the child walk alone into the woods. So you saw the kid walk alone in the woods, but you claim that it's the neighbor that you've had disputes with? That's pretty shady. A long fight to prove innocence post-conviction. The campaign to prove Mr. Grimm's innocence was fought in the courtroom and the State House. Mr. Grimm initially requested DNA testing in the late 1980s, but faced a number of hurdles. At that time, Virginia law did not allow post conviction DNA testing, and a writ of innocence did not exist. Even after the writ of innocence of new biological and non biological evidence was enacted, it was limited to people who went to trial, and when access to DNA was allowed, it was limited to laboratories to the state of Virginia. So only people who were going to trial had access to DNA testing back then. Now it's opened up to people who are on their post conviction, you know, um, within the process of post conviction, that they can often seek a petition or some kind of motion to get access to their DNA samples of the case that they're on. So, years of lobbying legislators in Virginia, an effort led by former Innocence Project directors of policy Michelle Feldman and Rebecca Brown, the Mid Atlantic Innocence Project, and the Innocence Project at the UVA School of Law led to changes in Virginia law. Because of their efforts, Virginia permitted access to post conviction DNA testing, created a writ of actual innocence, lifted the guilty plea bar, and allowed people accused of crimes to get testing in private accredited labs. And that is huge for people. This sentence, or yeah, this one sentence right here, that packs a huge punch. Because of these individuals, the Innocence Project directors of policy, and the Mid Atlantic Innocence Project and Innocence Project of UVA School of Law. All of them in combination helped change the law in Virginia, and now post conviction individuals can fight to get DNA testing in their cases to get their cases thrown out or exonerated or whatever. And that's huge because that is a big change. So, Mr. Grimm's exoneration took decades of painstaking investigation and litigation by a long list of attorneys and the Innocence Project and Arnold and Porter. Must be a law firm. In particular, Ms. Feldman and former Innocence Project attorney Olga Axelrod. These two lawyers spent a combined 2 decades working on behalf of Mr. Grimm. 2 decades to get him out, to get him free, to get him to clear his name. That's amazing. So thank you to those wonderful individuals who helped in that case. So the Innocence Project's senior staff attorney Tim Gumkowski also joined Ms. Friedman. More recently, Mr. Neufeld and Innocent Project's director of special litigation Vanessa Potkin added their expertise to the Innocence Project team. Arnold and Porter collaborated with the IP for many years, led by partner Jeffrey Horowitz and now retired Peter Glenn Pogist, senior attorney Robert Grass, and senior associate Angelique Celebrity. So thank you all to those individuals named and anyone who wasn't. Thank you for all your hard work at the Innocence Project. You guys do an amazing job and you really do it for justice, in the name of justice. University of Richmond School of Law's Institute for Actual Innocence, directed by Professor Mary Tate, also supported the legal efforts. Working to exonerate Mr. Grimm was truly a team effort involving not only our Arnold and Porter team, but also multiple attorneys over the years from the Innocence Project, and could never have been accomplished without the unwavering support of Marvin's sisters and entire family, said Mr. Horowitz. So there you have it. There's some information. Arnold and Porter. Yeah, it's a law firm, obviously. All right. So that is Mr. Grimm's, Marvin Grimm Jr.'s story. I love that picture of him. He's smiling. And I like the picture of him and his sisters too. They're smiling to have their brother back finally after 45 years. Imagine not knowing your sibling for 45 years of their life because they were locked up for something they didn't do. These things can happen to anybody. this kind of story can happen to any one of us. So this is why it's important to listen to read about these cases, learn about these cases, make sure that justice isn't going by the wayside for individuals sitting in prison for crimes that they didn't do. It makes me it breaks my heart, and it makes me sad at the same time, and furious. So I mean, it just evokes so many emotions in me. And there are ways to help. You could go to Innocence Project and donate. You can tell their stories. You can share this video. Make sure that this information gets out, because it's people like Marvin Grimm who are the lost innocents. They are forgotten. He, I'm sure, was a young man when this happened 45 years ago, and life just passed him by sitting in a jail cell. And we should all be furious. We should all be angry about this. And if you're not, I don't know, there's something wrong with you. If it doesn't make you mad that innocent people get railroaded, thrown into jail, they are forced to confess, sometimes by law enforcement, forced to plea by prosecutors. There's a whole seedy underbelly of the justice system that it just isn't getting a whole lot of focus. And I hope that you guys take the time to really learn and read about cases before jumping to snap judgments and just saying, oh, well, she smiled funny, so she's obviously guilty, or whatever it might be. I know you guys are intelligent enough to know that these things happen, and you just need to do better and make better decisions, especially keeping an eye on the powers that be, making sure that they are responsible for their actions and accountable. With that note, I leave you guys. Thank you so much for watching. I really hope that you enjoyed this. Hit the like button on your way out and take care. Bye now.
If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.